Involving local concealed carry permits will move forward. This after a hearing in U.S. District Court back in June, asking for a preliminary injunction requiring the Mecklenburg County Sheriff's Office to issue permits in a certain way.
Sheriff Garry McFadden and his office filed their own motion to dismiss. WCNC Charlotte's Jane Monreal is here to explain more. Jane, what is this all about?
Well, Colin and Vanessa, all of this stems from claims that the sheriff is taking too long to process those permits. And we just learned part of the lawsuit is going to move forward, but the judge denied the plaintiff's request for a preliminary injunction because the three people who filed the complaint have since gotten their permits, therefore rendering the request moot. When we met back in June, Paul Valone from Grassroots, North Carolina, compared the sheriff's process of granting permits to whack-a-mole.
Because he was delaying permits earlier by requiring extensive delays for fingerprinting. When we got an injunction solving that problem, he shifted to a different means of delay, and now he's basically flooding the Veterans Administration with mental health requests for people that never served in the military.
In North Carolina, in order to purchase a gun, state law requires a person to get a concealed handgun permit first, which requires a mental health check. And it is the sheriff's office that is responsible to determine whether the applicant can get that permit. This latest lawsuit based on two constitutional grounds.
One, that the statute that allows him to delay these concealed handgun permits is unconstitutional on its face, and also that it's unconstitutional as applied to the plaintiffs who are being denied their concealed handgun permits within the time allowed by state law.
Statute says within 45 days of the receipt of the items listed from an applicant and receipt of the required records concerning the mental health or capacity of the applicant, the sheriff shall either issue or deny the permit. The judge denied the facial challenge, meaning the statute, the way it is written, is constitutional. Valone says it is disappointing, but he is pleased the judge is allowing the as-applied challenge.
And so at this point, we look forward to doing discovery and holding the sheriff accountable.
Statute says the sheriff is authorized to, quote, conduct any investigation necessary to determine the qualification or competency of the person applying for the permit.
My impression is that they will basically query the sheriff on why he is doing some of the things he's doing.
Well, the judge also dismissed the Mecklenburg County Sheriff's Office as a defendant, leaving only Sheriff Garry McFadden on the lawsuit moving forward. I reached out to the Sheriff's Office. A spokesperson replied saying the sheriff will be standing by our policy not to speak on pending litigation. Live in studio, Jane Monreal, WCNC Charlotte.
Interesting, Jane. Thanks for bringing us that report.